And welcome everyone. Great to have you with us today. My name is Paul Gershlick. As some of you know, I am a partner at VWV, the law firm. I'm head of our pharmaceuticals and life sciences sector, and I'm also co-chair of the EMIG Compliance Special Interest Group. VWV, we have a great specialism in life sciences. We've been members of EMIG for about 10 years, and it's a pleasure to be bringing this session to you today. This session is being attended by people from the EMIG special interest, the Compliance Special Interest Group, as well as VWV's pharma and life sciences clients and other contacts. So wherever you've come from and wherever you're logging in from today, welcome, and we hope you enjoyed today's session. As Tamar just said, we would love to hear from you and to hear your questions. So please put them in the Q&A box. If you'd like them to be anonymous, please make that clear. We will probably keep it anonymous anyway, but please do make it clear if you particularly want to ask a question anonymously. When we look at our Compliance Special Interest Group in EMIG, when we set this up about 5 years ago, a theme that keeps coming up time and again is data protection. And I suppose it's no coincidence the GDPR is about 5 years old now, and it is still a very hot topic, hence the significant number of people who have come here today. We're going to be covering 4 topics in today's session. First of all, we'll be looking at cybersecurity. We'll be then looking at data sharing, and with a particular focus on the new IDTAs for the UK data export. And then finally, circling back to how to work with your employees and to keep them up to date when they are managing personal data on your behalf. This is a session which is for people in life sciences, but a lot of the principles apply widely. And just to say also that we have a variety of people who are attending this session today. Some of you will be doing a little bit of data protection, some not much, and some quite a lot. Whatever your role, we expect that you will be able to learn some things, some more than others, but certainly you will all be able to be updated on some of the latest trends. So keep the questions coming in, as I say, in the Q&A. And I would like to introduce, we have 2 speakers from our specialist data protection team at VWV. We have 7 people at VWV who all they do is data protection law. And I'm delighted to have with us today Vicki Bowles, a partner in the data protection group, and Bronwen Jones, an associate. And to kick things off, I'm going to hand over to Bronwen now, who's going to start us off on cybersecurity.
Thanks, Paul. Sorry, I'm Vicki Bowles, obviously not Bronwen. I was just going to introduce the first slide. So we've got an hour today. We're covering these 4 topics as Paul's outlined. We do only have an hour, so this is an overview of those topics, and hopefully it will pull out some of the key things to think about. Obviously, please, as Paul said, do ask questions, but if there's anything that you really want to get to into some detail, we'd be more than happy to take that offline, because obviously things like cybersecurity and data sharing and international transfers are actually quite big topics in and of themselves. So I'll now hand over to my colleague Bronwen to talk you through the cybersecurity.
Thank you, Vicki and Paul, and hello everyone. Good morning. I'm Bronwen, as Paul said, and I'm an associate in the data protection team. So to start things off, I'm just going to take a little look at cybersecurity. And really the prompt for this is, as some of you may be aware, Interserve Group Limited were issued with a high monetary penalty notice of £4.4 million, the fine came to. And really, this was as a result of a cyber attack. But I think what's quite useful to look at is the reasons that the ICO issued such a high fine and what we can take away from that in order to avoid that in future in our own organisations. So just a sort of summary here. So there was a cyber attack, and this occurred because an Interserve employee who was working from home, so this began at the start of the pandemic, March 2020, Interserve employee was working from home, and they forwarded a phishing email to another employee who subsequently opened that phishing email and downloaded the contents. The initial phishing email, it wasn't quarantined or blocked by Interserve's system, so it made it through. And unfortunately, the download resulted in malware being installed on the employee's workstation. So although Interserve's antivirus quarantined the malware and sent an alert, another failing was that then Interserve failed to conduct a sufficient investigation there. So it's sort of a string of failings that led up to this. The result being that a hacker was given access to 283 systems across 16 accounts, and they subsequently uninstalled the company's antivirus solution. So again, another failing. Ultimately, the personal data of up to 113,000 employees was encrypted and rendered unavailable. So where they take it and they won't give it back to you, essentially. The data that was compromised was really varied. It was across 4 HR databases. So you can imagine there's quite a lot in there. You've got national insurance numbers and bank accounts, but then also special category data around ethnic origin, disabilities, and that sort of thing. So ultimately, the ICO issued them with a penalty notice and a fine of £4.4 million. And in the penalty notice, they really break it down into the following areas that were failures. So a failure to ensure appropriate security when processing personal data. They're not using appropriate technical and organizational measures when they're processing the personal data. This resulted in a cyber attack, and it affected the personal data of a huge number of employees at Interserve. So I think what I'm going to run through now is just to take away some key points to help to avoid that from happening in future. Please may I have the next slide? So we mentioned just now failure to implement appropriate technical and organizational measures. Both of these work together, and that's important as evidenced by the Interserve fine. So technical measures are things like firewalls, encryption and backups. And then with organizational measures, we're looking at more procedural things, so policies and staff training. And I think here, the gaps in staff training, for example, awareness of phishing emails, meant that the technical failures were able to happen because the human error had occurred, which allowed the stuff to get onto the system, which meant that then that's when your technical measures should kick in. So it's a failure on both the organizational side and the technical side. Out-of-date antivirus software in particular was seen as a problem here. So some of the software was just unsupported, and some of it was a failure to install the latest updates. And I suppose we all know that annoying thing where you're trying to log on or you're trying to log off and it says, do you want to conduct an update? And you go, oh no, I don't have time for this. And you sort of think you'll do it tomorrow. But I think this really highlights the importance of stressing to staff, do the updates, make sure those updates are being done, because if they're not, it's back on you as an organization. So even though you think you've done everything you should have by having the software in place, it's keeping it updated that's really important. The National Cybersecurity Centre has a plethora of resources and really useful guidance on technical measures. So another suggestion is to go back to their resources and just check against what you have in place to make sure that you're happy that you've done everything that you can do as an organisation to protect that personal data, so that you, if something, the worst did happen, you can say, it's not our fault, we had everything in place and it was just a really clever cybersecurity hack. Please may I have the next slide? So some examples then of data breaches. I think we all know they're sending emails to the wrong recipient, email addresses being visible to all. So really this is misuse of the BCC function. And this can cause a lot of headaches for organisations because it's just if a member of staff is rushing. So this is again where training comes in as an important defence against any cybersecurity issues, because you can say to staff, this is how we do things as an organisation, don't use BCC and that sort of thing. You could then have your internal and external attacks, which include phishing and ransomware, as with Interserve. We've seen a real increase in the volume and sophistication of phishing attacks. These emails look very, very genuine now, so that in previous times there might be poor spelling, poor grammar, it was a real giveaway. These are branded emails that look like they're coming from a genuine recipient, sometimes someone inside the organisation, so posing as the CEO and having a very similar email address, maybe with just one character different, which would be quite difficult to spot. So the training of staff on what to go through as a process before just trusting an email that looks like it comes from a trusted source can really prevent headaches in future. Mousing over links, not clicking or downloading anything. And if you're unsure, send it to your data protection lead or your IT team or whoever leads on that. And then a third type of data breach is the hardware data breach, which I think is probably on the decline due to the decline of use of USB flash drives, but still to be wary of plugging in hardware into a company laptop, for example. It needs to have been checked by IT and all cleared before that's done. Please may I have the next slide? So the consequences and risks then of data breaches quite varied. I'm sure we're all now, 5 years after the GDPR, quite aware of the fines of up to £17.5 million or 4% of global annual turnover, whichever is the greatest. In addition to that, though, you've got compensation of individuals who might bring a claim alongside any monetary penalty that's issued by the regulator. And then you've also got diversion of resource and management time. And I think this is a really underrated risk, but it is a big headache for organizations to deal with these things. Even if you're not reporting the breach, even if it doesn't meet the threshold for reporting, to get to the point of understanding whether or not it does is going to divert resources away from other valuable projects. And so it's normally the most senior people that need to deal with this. So the cost to your organisation and the loss of that time through them having to look into this can be quite significant. So it's not one to be overlooked there. Enforcement notices and reputational risk. The ICO publishes its enforcement notices. So that will come up as part of a Google search for your organisation's name. So even if you weren't issued with a fine and you get away with it on the monetary side, there's still a reputational risk there to these things. And then personal liability and liability for processors. So Vicki will talk later on a bit more about service providers as processors, but just to be aware of sort of trying to go through that chain of who's liable for what, and that can take quite a lot of time away too. Please may I have the next slide? So then practical tips, what can we do to avoid being in that situation in the first place? I think carrying out regular testing is one of the biggest things to come out of the Interserve fine. Had they had regular penetration testing, technical testing, also practical tests for their staff, dummy phishing emails sent out so that people get an understanding of what these things look like. I think that would have identified gaps in the knowledge and gaps in the technical security there as well, which would have allowed them to fix those things before it became an issue. So they could test the vulnerabilities in their information security setup and then work with an IT provider to fix them. So alongside that, I think staff training is really, really key. So obviously everyone gets trained at the outset of an employment relationship, but refresher training can just help to jog people's memories as well of, should I just be clicking through and doing that? Or does that look suspicious? Or have I not filed something in the correct place? Or that sort of thing. So practical staff training that can either be in person, it can be online, whatever works for the size of organisation you have. But the advantage of that is that if you do have to report to the ICO at any point, you can also show them your staff training log. So you can show that the particular member of staff have been trained recently and it was just their failing, but not failing on the organisation's part, because you've done everything that you possibly could to prevent that breach from happening. Another good practical tip here is carrying out due diligence on contractors and service providers to ensure that they've given you enough information security assurances so that if something does go wrong, which involves a service provider handling your personal data, you can say, well, we didn't expect that to happen because they told us they did things this way, and actually it's their fault, and you can sort of pass that liability further down the chain. And then evidence through policies and procedures, which I mentioned earlier, the organisational measures. So not just a case of having a suite of policies in place, but having them to work alongside your staff training. So the two things support. So staff know where to look in a manual or whatever you have for the relevant information if they're unsure of what's gone on, and just making sure they're accurate and up to date as well. So if you do update your software system when you change your payroll provider or something like that, everything there is updated, it's the latest information so that it's not out of date if you need to report to the ICO. And then finally, updating software. It really was a key weakness that resulted in the Interserve fine, and it isn't enough to just install it. It needs to be regularly reviewed, refreshed, and updates installed as well. So I'm going to hand over to Vicki now to talk to you about data sharing and also international transfers. Thank you, Vicki.
Thanks, Bronwen. If I could have the next slide, please. So we'll start off with talking about data sharing, and there's two types of sharing. There's internal sharing and external sharing. And what I mean by internal sharing is the sharing within your organisation of information. So sharing with other employees, with other departments, however that might work. And then there's the external sharing of information, which is the sharing of information outside of your organisation. So with a third, what we would call in data protection terms, a third party. If you're talking about external sharing, then I have a cat who I tried to shut out and she's just knocked everything off my desk. So I'll just wait for her to finish and then carry on. Right, external sharing. If you are sharing with your organisation is sharing personal data with a third party, you will be doing it on one of three bases. So it will either be controllers to controller sharing, joint controller sharing, or a controller processor relationship, or a combination of those. And just by way of sort of introduction to those concepts, a data controller determines the purposes and the means of processing. So if you decide how, why, and what is being shared and what you're doing with the data, then you will be a data controller. If you have two separate third parties who are working together to determine the how and the why of data sharing, then you will be joint controllers. And the final piece of the puzzle, if you like, the processors, that's a third party that doesn't determine the how and the why of the processing. They're just carrying out instructions on your behalf. Could I have the next slide, please? So if you're sharing internally, so I was talking about the controller and the processor and the joint controller relationship just now. That's, as I said before, that's your organisation with a third party. If you're just sharing within your organisation, it's important to remember that you should really only ever share personal data on a need-to-know basis. So before you share the information or before you set up your access controls and work out who's going to have access to personal data, who actually needs to have access to this information in order to do their job. And the classic example is HR information about employees. The HR team need to know that information. It's possible that certain senior managers within the organisation may need to know that information, but actually other employees don't need to know that information, so they shouldn't have access to it. You then need to consider the technical measures you can put in place to prevent access. Now, Bronwen was talking about cybersecurity earlier, and she talked about organisational and technical measures. And quite often we think of technical measures as being those measures that the IT team need to sort out because it's an IT issue. And actually it's not. There are technical measures that perhaps the IT team have to implement, but other people in your organisation will be responsible for setting the parameters of. And some of them aren't actually so complicated that you need necessarily to involve IT. But a technical measure to prevent access is access permissions, so access control. And what I mean by that is making sure that only the individuals who need to see information have access to that information. On our system at VWV, I can access my own personnel record, but I can't access the personnel records of anyone else because I have no need to see that information in order to do my job. So there is an access control in place there. And part of that can be looking at your information management software. So what software do you use in your organization? Does it have will have the ability to set access permissions? And do you need to, so you have the permissions, you might also need to think about password protecting documents, etc. That's another access control, if that's helpful. And it's also important to remember that seniority does not give an automatic right to information. And we see this quite often within a range of organisations where there ends up being a data breach because somebody senior, say a CEO or a CFO, has said they need to see a certain piece of personal data, and actually they don't need that level of detail in order to carry out their own obligations. So that then becomes unauthorised, potentially unauthorised access. Could I have the next slide, please? So when you're talking about external data sharing, so data sharing from your organisation to a third party, the first step, in my view, is to identify the relationship. So I talked earlier about the controller, the joint controller, or the processor, or that you can be a combination of those for different purposes of processing. So the first thing is really important to do is identify the relationship, because once you know what the relationship is, you can then identify whether or not you need an agreement and whether there are additional legal requirements in place. So identify what is the relationship. Are we acting just as a controller? Are they acting as a controller? Are we joint controllers? Are we joint controllers for this purpose, but they're a processor for that purpose? Or how is this arrangement working? It's then important to make sure, again, that you're only sharing the minimum amount of personal data. And again, that is a legal requirement, the principle of data minimization. So making sure that actually, and when we talk about the minimum amount of personal data, that's the amount of personal data that is needed to facilitate that relationship. So in some cases, it will be a lot of data. If you are instructing a third party to carry out your payroll, they need information about all your employees who are going to be paid, and they need the information about those employees that they need in order to process that payroll for you. But they don't necessarily need to know, say in a law firm context, what cases I happen to be working on that week, because that's not relevant, directly relevant to my pay. So only share the minimum amount of personal data and wider information that's needed. Make sure that you've got a lawful basis under the UK or the EU GDPR is applicable. If you're only subject to the UK GDPR, you only need to think about the UK GDPR. If you're also subject to the EU GDPR, then you need to think about that as well. The lawful basis at the moment are the same. So what you choose for one should translate easily across to the other, but make sure you do have that lawful basis. So are you relying on consent? Is it a legitimate interest? Is it a public task in the public interest? What's that lawful basis? If you're going to be transferring special category personal data, so what we used to think of as sensitive personal data, and I think a lot of us still do think in those terms, make sure you've got that Article 9 condition. So again, is it explicit consent? Is it some obligation under employment law, or what is it substantial public interest? What is that condition? Make sure that this type of sharing is covered in your privacy notice. So if it's something new that you're doing, if there's a requirement to tell individuals about it under the privacy notice information, make sure that that's updated and covered. And finally, and definitely in a last but not least category, consider security. So how, if you are transferring information, how are you transferring it? How are you making sure that that transfer is secure? Could I have the next slide, please? So I think we mentioned on the publicity for this about the Department for Education, because they got in trouble for some data sharing. And Department for Education collect a lot of information about pupils on a regular basis, and they have a database of information. And they grant access to various, usually research organisations, to this data so that it can be used for that purpose. And they had a company who had access to the information previously. The company changed hands and actually changed purpose and said to the DFE, well, we've changed hands now, can we still have access? And the DFE didn't actually undertake any kind of due diligence on this new entity. So what was happening was it was being used as a database to check someone's age when they were signing up to online gambling. Now, clearly that's not the purpose for which it was collected. It's not, the DFE talk about this database being used for research purposes. Well, again, that's not a research purpose. It wasn't covered in any of the information that they were giving. So lessons to learn. Always carry out checks on your partners, and we talk about that in relation to data processors, but also think about the purpose of the sharing. So if you are being asked to share information, actually, why am I sharing this, and what's it being used for by the third party, and is that actually appropriate then for me to enter into, or for us as an organisation to enter into that arrangement? Could you have the next slide, please? So in terms of the legal requirements, if you are pure controller-to-controller sharing, there is no requirement to have any kind of agreement in place. However, in some cases, particularly if it's high risk, or if you're using special category personal data, you may want to consider having some sort of agreement in place so that it's clear what the expectations are of both parties. Particularly if you want to place restrictions on the use of the data, an agreement can be helpful for that. And if there is any risk here, if you've got an agreement in place, it gives you a contractual basis for a claim, potentially, if the third party is doing something that you're not happy with. The ICO has a data sharing code of practice, and that code of practice sets out a sort of gold standard of data sharing agreements. And what I would say is that it's great and it's useful as a starting point, but you don't have to follow the data sharing code of practice to have a valid data sharing agreement in place. A data sharing agreement, controller to controller, there are no legal requirements, so you can do with it, you can fit it to specifically to your purpose, but the code of practice can be helpful in setting out things to think about and things to consider. If you are a joint controller, so you and your third party are jointly determining the means and purposes, you need to have an agreement about who is going to deal with individuals exercising their rights and who's going to deal with privacy notices as a minimum. In most of the joint data controller arrangements that I deal with on a regular basis, everyone deals with their own. So I will answer questions from individuals about whom I process the data and how I do it, and you will answer them about how you process the data and what you're doing. And we'll each put the information in our privacy notices. But actually, in some cases, if you've got a lead partner, for example, they might want to be responsible for collating the information in relation to a subject access request, for example. But it's completely up to you as long as that is covered. That's the minimum. You can cover lots of other things about security and purpose and all of the things that you might cover in a controller-to-controller agreement, but that's not a legal requirement. So that's up to you, depending on whether it's helpful in the circumstance. The other legal requirement in relation to joint controllers is you must make the essence of the agreement available to individuals. Now, that's the wording of both the UK GDPR and the EU GDPR, and quite what the essence of the agreement means is up to interpretation really, but essentially I think as an individual they need to understand that there are two parties jointly processing their data for this purpose, and they need to understand who do they contact in order to exercise their rights and who do they contact to get the privacy notice information, etc. So making that sort of information available is likely to be enough. Could I have the next slide please? And finally, your data processors. So if you're using any kind of contractor or service provider and they are processing some personal data on your behalf under your instruction, I mentioned payroll providers, cloud storage providers are another good example of a data processor. So they have your personal data because they're storing it for you, but they can't do anything with it. If you use Microsoft or Google systems, operating systems, they are a data processor because they are holding and processing, doing things with your personal data, but they're not actually entitled to do anything themselves with that data. They can only do what you instruct them to do. So they are types of data processors. If you have a contract with a data processor, or even if you are acting as a data processor for someone else, you must have a written enforceable contract in place that contains the Article 28 mandatory provisions. So in Article 28 of both the UK GDPR and the EU GDPR, there are a number of provisions which the law says must be included in these contracts. And in order to be compliant, all of the provisions have to be in there. So it's not a cherry pick the ones we think we like, and it's a yes/no question. So if I'm asked to review a processor agreement, if it has one of those clauses missing, it's not compliant. And it's usually the requirement to audit, if I'm honest, that's the one that's usually missing, but it has to have all of them in. You also have to be satisfied that your processor has given you sufficient guarantees of data protection compliance, which essentially means carrying out some form of due diligence on your processes. And this is the bit that, to be honest, most organisations don't do. And I see this across sectors. So nobody is doing this essentially, or nobody is recording it. And I think what usually happens is if you are thinking about a cloud storage provider, top of your mind is, what do I need it to do and how much is this going to cost? So you're not necessarily thinking about data protection compliance, but it is something that you should be factoring in and looking at their compliance statements, their privacy notices, what they say they do in terms of technical and organisational security measures. And as a nice segue into my next section, there are extra rules that apply when you are transferring data outside of the UK or potentially the EEA as applicable. Next slide, please. So international transfers, I think we can flick straight on to the next one if that's okay, thank you. So the key points, I'm sure most of you on the call will be aware. You cannot lawfully transfer personal data outside of the UK without a safeguard in place. If the EU GDPR is applicable to you, then you can't transfer information outside of the EU or any EU country without a safeguard in place. There are a number of safeguards. I've listed the 4 key ones here where there's been an adequacy decision. So for if the UK GDPR is applicable and you want to transfer information to any organisation within the EEA, there is an adequacy decision there, and it works both ways so that we can transfer information between the UK and Europe without needing to do anything else. If you're transferring somewhere where there's not an adequacy decision, then you may be looking at contractual clauses to put in place. You may be looking at a derogation, so there are certain situations in which you don't have to put in place a safeguard, or you may be looking at getting explicit consent from the individuals. Could I have the next slide, please? And what I've focused on just in this section is the standard data protection clauses, or the standard contractual clauses. So many of you will be familiar with the EU standard contractual clauses, which is what we used to put in place if there was an international transfer. You just stick them on the end of your service agreement or whatever it was. But actually the old EU standard contractual clauses are no longer valid for new transfers. So if the UK GDPR is applicable to the processing that you're doing, and you are transferring information to a country that doesn't have an adequacy decision. And you've got the old EU standard contractual clauses for that purpose. You can't use them. You're going to have to transfer over to the new UK regime. So the UK now has two potential sets of standard contractual clauses. Essentially, we have the International Data Transfer Agreement, the IDTA, or we have the UK Addendum to the European Standard Contractual Clauses. So you would use one of these depending on the situation. Next slide, please. So the IDTA is a standalone document, so it can be entered into as it is, but it can also be annexed or referenced to an existing agreement. Arguably, it's an easier read. It's also arguable that it's slightly more flexible in practice because there are various ways in which you can link it to existing agreements or documentation. Could I have the next slide, please? If you're thinking about using the ICO addendum, so rather than the IDTA, the addendum to the standard contractual clauses, so you have to use the standard contractual clauses and then you put this addendum with that. It might be more familiar to international partners because if they're used to the old standard contractual clauses, the EU ones, then you're still using them, you're just adding a UK dimension. They're potentially easier to use as part of a wider agreement. And also the EU standard contractual clauses have your Article 28 processor clauses in them. The IDTA doesn't. So if you are transferring, say, from the UK to a processor that's based in, let's say, the US, and you want to use the IDTA, you will also have to put in place processor clauses separately or in addition to the services agreement. Next slide, please. So the question to ask yourself if you're thinking, do I need to use the IDTAs, is whether you're making a restricted transfer. Could I have the next slide, please? And over the next few slides, I've just gone through the questions there that the ICO sort of checklist asks. Given that we're a little bit tight on time, I'm not actually going to go through these. You'll get a copy of the slides, so you'll be able to read them at your leisure. But essentially, if you go through these questions and you're asking and you end up going through to the end, then you'll know that you're making a restricted transfer and you need to put things in place. So could we just flick through those slides? Thank you. Now, I appreciate that there's a lot of it, that's a lot of information potentially squished into 10 minutes. So we were wondering actually whether a webinar exclusively covering international data transfers would be of interest, because if it would be, we can put something on that's a lot more detailed. So we've got a poll there. If you could just answer yes or no as to whether it would be of interest, that would be really helpful. And if it's of interest to enough people, then we can look at putting that on at some point. Just give everybody a second to vote, and then I'm going to hand back to Bronwen now to take you through our last section.
Hello again, everyone. So the next section is about employees and personal data. And when I say employees, obviously paid members of staff, that makes sense, but thinking about that more broadly as well. So really anyone that's going to handle personal data on behalf of your organisation needs to be clued up on what they need to be doing to protect that personal data and how that works from your perspective. So this will include volunteers, if you work on a volunteer basis, who might handle personal data. It might include any governing organisational structures that you have. So if there was a trust set up, then trustees who might be handling personal data. So it's thinking about it more broadly than just your basic employee relationship, consultants and contractors as well, even work experience placement students, just trying to think about this more broadly so that you don't miss out on capturing someone who could do with some training. So what do you need to be thinking about? Accountability is really important under the UK GDPR. So organisations being accountable for their actions and being able to demonstrate their compliance. It's this idea of data protection by design and default. So instilling an awareness of personal data into the fabric of the organisation, so it becomes second nature and not an afterthought. I think in the same way that compliance with other regulatory bodies is seen as such a huge thing, you know, if you're being audited or whatever, it's you want to demonstrate your compliance. Compliance with data protection should be looked at in the same way as well. So linking those all up together so your standards are the same there, rather than it being sort of a box ticking exercise. So Interserve had security standards in place, but they hadn't adhered to them. So that was more box ticky from their perspective rather than embedding it really into the fabric of their organisation. So you're not just writing some policies and sticking them in a drawer, but having them as live living documents. And then having measures in place that are proportionate to the risks as well. So the more personal data that you process, the more sensitive it is. So thinking about special category data here, medical information and that sort of thing, the more sensitive that data is, the more stringent the measures need to be in order to protect it, because the risks that I talked about earlier in the session really increase with the sensitivity and volume of personal data that you're processing. Thinking about explicitly required documents as well, which I will come on to shortly when I talk about documents. Could I have the next slide, please? Thank you. So procedures and policies, what should they be covering? The essentials, what data you process, where it's stored, who has access to it, those sorts of things. That sort of information will probably be captured in privacy notices and guidance for staff. You've then got information security. How are you keeping your data safe? And most importantly, who should assist with this? Who are you directing people to? Giving practical examples that relate back to an individual's role as well. So if you're processing lots of paper personal data, where's it kept? Are we thinking locked filing cabinets? Who has access to those keys? What to do in the event of an emergency there? If you'll have more electronic filing, where to file things on the system, as Vicki was talking about earlier, access on a need-to-know basis, so codifying that somewhere so it's very obvious who should be accessing what level of information. And then data breaches, what to do, who to contact, what not to do. So for example, paying of ransoms, that can often go wrong where individuals panic and think, I'll just pay it and we'll get the data back. And quite frequently you don't get the data back, so it's a waste, and it's also funding criminal activities as well. So not to panic, not to make these mistakes that will then compound an already bad situation and make it worse. Retention, data minimization. So everyone's inboxes are absolutely stuffed these days with emails. It's just the volume of internet email traffic is huge. So trying to remind staff about reducing the volume in their inbox. Does that need to be in my inbox, or could that be sitting in a centralized filing place? So if you were dealing with a grievance or a disciplinary, putting that into the specific section of the HR file, rather than having a huge amount in your inbox, which increases the risk if you do have a cyber attack of more sensitive information being accessed by hackers. Because if it's not sitting in the inbox and the inbox is the only thing that's compromised, then they won't be able to access a huge amount there. So moving it to more secure places, sitting on an information management system that's maybe hosted by a third party, as Vicki was talking about earlier. Using photos and videos. So this is an interesting one. Photos and videos are people's personal data, and it's easy to sort of forget that in the moment and just think, oh, that's great, let's post that to social media. But just before you do that, what's your strategy on photos and videos? Are you asking for consent? Are you using it for marketing? Have you got buy-in from the relevant individuals whose photos and videos that you would like to use? Because that's often where some complaints happen, is if people's information is used outside of their expectations, for example, in a public way in a social media campaign. CCTV, if that's relevant, if you have CCTV, have you got your notices in place? Have you got a policy on what you're doing with it, how long you're keeping it for, and that sort of thing. And then finally, thinking about data protection impact assessments, which are only required in certain circumstances, so where the type of processing is likely to result in a high risk to rights and freedoms of individuals. But sometimes you can do a nice to have DPIA if you're going to implement a new technology that might be a bit more privacy intrusive, or you're thinking of changing over a huge information management system that's holding lots and lots of personal data. You might want to do a DPIA before you do that, because that can flag some issues which you can then resolve prior to implementing and moving the data over. Ultimately, the documents need to work for your organisation, include practical points, and be available for staff when they need them. Can I have the next slide, please? So there are some documents that you are legally required to have. It's explicitly laid down in writing that you must have that document, for example, privacy notices. And then there are others that are nice to have, but are still important because of the general obligation to demonstrate compliance and the principle of having data protection by design and default. Please, may I have the next slide? So things that you need: privacy notices, in particular specific to individual data subjects. So maybe consider having one for staff, one for website visitors, another for contractors, customers, clients, making them as tailored as you can. Your data breach register, and this needs to be filled in even if you don't report the breach. So putting non-reportable breaches down on there. Retention policy, which we've talked a bit about before, so I won't linger. An Article 30 record of processing activities, which dovetails with all the other policies because it sort of gathers together all that information that you've already got and puts it in one place centrally. And then your appropriate policy document, again, only applicable here. You're nice to have your guidance, but I think these are the more useful documents when you're looking at a cybersecurity incident, because these are the ones that are going to point to the practical things that you've put in place. So although there's nowhere that legally says you must have these things, they're just good to have in support of all of your other things. In particular, the data breach policy to support the data breach register, because that's what to do if this has happened before you get to the point of filling in the register. Can I have the next slide, please? Finally, I just wanted to touch on transparency. I know this is a topic that gets quite a lot of airtime anyway. Privacy notices are something that are discussed at length. The recommendation from the ICO is to have a layered approach. So splitting those privacy notices out so you don't end up with one huge document that's really unwieldy, difficult for people to navigate to find what's applicable to them, especially if you're only processing a really tiny bit of their personal data. So just considering how it looks to the data subject and how accessible it is. The more accessible it is, the less likely it's going to be open to criticism from the regulator. And when you provide these, so when you collect data via a form, would it be possible to append the privacy notice to that form, and then you don't forget to pass it on in future, because it does need to be provided fairly swiftly. So just looking at the practicalities behind just having the document and sort of saying, well, we've got a privacy notice, that's it. Are you providing it to people? Is it still relevant to what you're doing? Have you changed your processing activities? Might it need a refresh? Could I have the next slide, please? And so finally, I just wanted to talk about e-learning. I've talked quite a lot about training and how useful that can be to flag gaps in staff knowledge. So we have put together a VWV Plus platform, which sort of gathers up all of the knowledge that we think is really essential for all staff to know when they're processing personal data. And it covers various different topics. It's interactive, and it has kind of tick throughs and videos and that sort of thing. And that's really the kind of thing that I've seen to be most useful for training staff, rather than just having them sit in a room where sometimes it can be a bit difficult to relate that back to your real role and how you handle personal data. So I think there's going to be a poll coming up. Yes. just if you would like us to contact you with any more information about the e-learning, if that would be useful, do let us know. Has everyone completed the poll? I don't know if I'm able to see that. Okay, I think everyone has completed the poll. So if we move on to some questions now, and if I invite Paul and Vicky to join us back here.
Thank you very much, Bronwen, and thank you, Vicky. So we've had a few questions. Time is limited, so let's see how quickly we can get through these. First of all, if I've understood the question correctly, because I've gone backwards and forwards a couple of times, is it for transfers based on the adequacy rules, do these apply automatically? So in other words, the UK and EEA have this adequacy, mutual adequacy actually now, isn't it? Is there anything more that needs to happen, or does it apply automatically?
Essentially, no, it applies automatically. So the purpose of the international transfer regime is that if you are transferring data to a country that doesn't have data protection laws, the data isn't protected. Because the EU has data protection laws, it's protected in the same way that it is here. That's what the adequacy means. So adequate data protection laws in that country. So that means the data is safe. So the UK is fine with that. And so it applies to the EA. It also applies to various other countries that previously the EU had said had adequate regimes in place, but it's now down to the UK Information Commissioner. So all of the adequacy decisions that were in place prior to Brexit apply, but post Brexit, it's then for the ICO to decide if a particular country has adequate data protection laws in place, and if it does, then they give an adequacy decision, and once that decision is in place, you can transfer without needing any safeguards.
Thank you, Vicky. That's great. Another one, sticking with the European theme. If you have European nationals working in your organisation, are you subject to EU GDPR?
I don't think you are in that situation, because it depends. Whether or not you're subject to EU GDPR depends on what your organisation is doing. So the fact that you employ EU nationals, I don't think affects that. You will be subject to the EU GDPR if you essentially offer goods and services directly to people based in the EU, or if you are monitoring the behaviour of individuals based in the EU. So the fact that you have employees who are European nationals doesn't tip that balance. So if you're a UK organisation just processing UK data, you happen to have EU nationals working for you, you just apply the UK GDPR.
Thank you, Vicky. Another question, if we're using, say, a Microsoft Outlook domain for sending files with private data by email, internally or externally, do we need to sign a data processing agreement with Microsoft?
The answer is yes, but you will have already done that because Microsoft, as you might expect, have a data processing agreement as part of the terms and conditions. Now, you won't have read it because nobody ever reads terms and conditions, but when you signed up to use Microsoft, you will have signed up to that data processing agreement. Usually for larger organizations like Microsoft, these things are incorporated automatically, but it's always worth somebody just double checking at some point that it is automatically included, because some organizations, and I can't think of any examples off the top of my head, but some fairly common large processors, you actually have to request to sign up to the processing terms. So if you haven't made that request, you haven't signed up to them.
Thank you, Vicky. And we've got time for one more, but I think it's going to be too long an answer, to be honest, because I think it delves into quite a lot. So let's see what you can do with this. Are names and designation of emails by employees considered as personal data? If so, how can you, on subject access request, produce all the emails that might have gone to and from such data subject, especially with international transfers? So I think there's a few really complicated questions rolled into one. I don't know if you've got a quick point there, because I think we've probably got 1 minute left before we wrap up.
Did you want me to take this
Yeah,
one?
do you want, yeah.
Yeah, that's fine. So it's a complicated one. It really depends on the content of the email. So not every email that's sent by a member of staff is necessarily going to be their personal data. So just because it's got someone's name on it doesn't mean it's their personal data automatically. It needs to relate to them. So emails of advice that I send at VWV to clients, those aren't my personal data, unless someone made a complaint and said, oh, Bronwen's rubbish, and I really didn't think that was very good advice, I didn't rate it, and that might then become my personal data, the advice. So it's very context specific. In terms of how you can produce all the emails, if a request for everything has been made, and that is a massive amount of information, you can go back to the data subject and ask them to clarify exactly what it is they're seeking. So you can put together an email that asks for, are you interested in emails to and from specific individuals, or date periods, or in relation to an event. There's no legal obligation for them to provide that clarification. So it's possible that you might still be in the same situation of having to decide yourself then what you're going to provide, and the obligation is to do what's reasonable. So using your judgment, pick either a date period or something that makes sense in the context that the request has been raised in, and do it that way, rather than searching through thousands of emails it can sometimes be.
Thank you very much, Bronwen. That was excellent. I thought that was a pretty difficult set of questions there, and both of you handled them well. And thank you for such an excellent session. Before we go, everyone, I just wanted to bring to your attention a couple of events that are going to happen. First of all, the next compliance event that will be on the 24th of April. Competition law, as we know, is really affecting pharma. The competition authorities are all over pharma. We will be hearing from Tom Pascoe, a leading barrister in this area who's involved in a big case in pharma on competition law. And also just to mention that at VWV, in association with EMIG in June, we have the PING conference. It is post-Brexit and COVID life sciences challenges, navigating stormy waters, with a focus on different difficulties with regulatory approvals, the VPAS scheme, which is making people wonder whether pharma can still supply profitably in this country at the moment, and issues over space and staff. Can you get the staff? Well, you'll find out if you want to come to that conference. It will be held at the beautiful location of Hatfield House in June. If you'd like to find out more, if you'd like to be on the mailing list to receive the invite, or if you want to receive the VWV Pharma updates, please let us know. Please also let us know, Bronwen, Vicki or me, if you've got any questions about data protection that haven't been answered today yet, or that if you'd like to hear anything more for future sessions.